and welcome. Continuing interdisciplinary education is important. It promotes effective planning, implementation, and operation of all forms of justice and treatment partnerships. And that is why the Association of Justice and Treatment Professionals exists. And that is why we are pleased today to have an expert in Judge Karen Ruddy to talk to us about the Yukon Community Wellness Court, the why, the how, and the impacts. And before we hear from the Honourable Judge Karen Ruddy, I shall address some housekeeping matters, which will give us some time to have more people join us. So panelists are reminded to keep their microphones muted when they are not speaking and unmuted when they are speaking. And one of the things that we love to do during these sessions is we love to engage with you. And so I encourage you to use the Q&A button, send in your questions. Kimberly Briggs will take them, and at the end of Judge Ruddy's presentation, we'll have a chance to engage with you in form of question and answer. Now this, as I've always said, is a team effort, and our thanks to Mary Pagani of PAC, Kimberly Briggs of the University of Western Ontario, Andrew Rivard of Ontario Legal Aid, Jennifer Graham of Crown Attorney Brampton, Ministerial Attorney General, and the organizing committee that helps to put this together. This session will be recorded, and we are grateful to Judge Ruddy for agreeing that this can be recorded. It will be recorded in about 72 hours or so. A copy of this proceeding will be available on the www.justicetreatment.org website. And also, you can follow the work of the AJTP on Twitter, LinkedIn, and also you could subscribe to the mailing list at justicetreatment.org. And now that I have taken my time to go through the preliminary matters, now it's time to do something very important. And so I'll turn to Mary Pagani to now do the land acknowledgement.
Okay, thank you, Justice Barnes, and welcome everybody. So today we'll begin this webinar by acknowledging that we are meeting on Aboriginal land that has been inhabited by Indigenous peoples from the beginning. As settlers, we're grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. Long before today, as we gather here, there have been Aboriginal peoples who have been the stewards of this land. In particular, we acknowledge the Anishinaabe, the Huron-Wendat, the Haudenosaunee, and Ojibwa and Chippewa peoples, the land that is home to the Métis, and most recently, the territory of the Mississaugas of the Credit First Nation, who are direct descendants of the Mississaugas of the Credit. We recognize and deeply appreciate their historic connection to this land. We also recognize the contributions of Métis, Inuit, and other Indigenous peoples have made, both in shaping and strengthening this community in particular, and of our province and country as a whole. As settlers, this recognition of the contributions and the historic importance of Indigenous peoples must also be clearly and overtly connected to our collective commitment to make the promise and the challenge of truth and reconciliation real in our communities, and in particular to bring justice for the lives lost in residential schools, as well as all the murdered and missing Indigenous women and girls across the country. Thank you.
Thank you, Mary. The topic today, as I've indicated, is the Yukon Community Wellness Court, the why, the how, and the impacts. Judge Karen Ruddy is our expert. She attended the University of British Columbia and obtained a Bachelor of Arts in English Honors in 1987, and then went to the University of Victoria, where she obtained her law degree in 1990. She has had an esteemed career in private legal practice and also an esteemed career in the federal government. At one point, she was a regional director of the Department of Justice, Canada. Now, in 2004, Judge Ruddy was appointed to the Territorial Court of Yukon. It was October 29th, 2004. And Judge Ruddy has, during her tenure, actively been involved in domestic violence treatment court and also in the creation of the Community Wellness Court. And also at different times during her judicial career, for a total of 7 years, she has been the Chief Justice of the Territorial Court. I have known Justice Ruddy for some time. I've had opportunity to hear her speak. It is a pleasure that you're able to join us, Judge Ruddy. And with that, I'll turn it over to you.
All right, thank you. May I say first, I'm really uncomfortable with words like expert because I work much better to lowered expectations. So I don't know that I'm an expert, but I can share with you what our experience has been. Make sure I get the right. Sorry, I'm just trying to share my screen here. All right. Hopefully this works. Or maybe not. My apologies. I'm just trying to get it to go to slideshow. And it does not seem to want to. All right, while I'm trying to figure this out, I will talk at the same time about what I'm going to do. But before doing that, we have had land acknowledgement where a number of you are. And I just want to acknowledge that at this point in time, I'm on the traditional territories of the T'An-Kwachin Council and the Kwanlindun First Nation. There we go. Hopefully everybody can see my screen now. So I'm going to talk to you today about our Community Wellness Court. For those of you who've been involved in therapeutic courts, there may be overlap in terms of what I talk about with what other people are doing. I suppose what makes us different to some extent is the fact that we are in a fairly isolated region of the country with limited resources. So part of the question is, how do you do this work in those circumstances? So let's talk first about what the Community Wellness Court is. We launched it in June of 2007. So we've been running the court for 15 years now. It's a judicially supervised therapeutic program that aims to provide treatment and support to offenders that are struggling with one or more of the following: an alcohol or a drug addiction, mental health problems, or intellectual or cognitive disabilities, including fetal alcohol spectrum disorder. So before launching into what it is, I want to introduce you to where I come from, because you can't be from the Yukon and not do your bit for Yukon tourism, because it's one of the 3 pillars of our economy, along with mining and federal transfer payments. So this is where we are located. We are up in the northwestern part of Canada, directly adjacent to Alaska. And directly above British Columbia. In terms of the demographics, the entire population of the territory is about 43,000. 33,800 of those all reside in the capital city, which is Whitehorse. We have a 23% Indigenous population. There are 14 different First Nations in the Yukon. That 11 of whom have signed self-government and land claims agreements, and several of whom are currently negotiating administration of justice agreements. So we're going to see a lot of changes in the justice field over the coming years as a result of that, which should be beneficial for the territory, and I expect fascinating to be involved in. So we are in a fairly isolated place. The Territorial Court that I sit in is based in Whitehorse. We also sit on a circuit basis in 14 other communities around the territory, most of which we attend 6 times a year. But I will say in my pitch for tourism, here's an introduction to why we live here, notwithstanding the fact that we are in a remote area. It's one of the most beautiful parts of Canada, and I would urge you to come and visit should you ever have the chance. But let's talk about Wellness Court. So how Wellness Court got started for us, we'd had a significant amount of success with restorative justice and other alternative approaches. Circle sentencing, for instance, the first circle sentence ever done was done in the Yukon in 1992 in Mayo. We also launched a domestic violence treatment court in 2000 that we'd had a fair amount of success with. And then in, I believe it was 2005, the federal government came out with the call for proposals for drug treatment courts. That led us to strike a group in the hopes of perhaps securing funding to launch another therapeutic court. Our difficulty, again, comes back to our size. We simply do not have the numbers to support a straight drug treatment court. So what we did instead was create a multidisciplinary committee to start talking about what are our issues? How might we, if we received funding, develop something that would address the underlying issues that we are seeing repeatedly in our courtroom? So that led us to identify alcohol addiction, which first and foremost, the Yukon has the highest per capita rate of alcohol consumption in the country. I think Newfoundland's second, and I can tell you they're not even close. So it is a significant issue for us up here. We also have some issues with drug addiction. At the time we launched, it was a significantly less serious issue in the Yukon, but I can say we, like the rest of the country, are experiencing increasing problems with particularly opioid addictions in the territory. So it's become an issue that really has come to the fore. Mental illness was next on our list of issues that we're seeing in terms of what's driving involvement in the justice system. And lastly, cognitive and intellectual impairments, particularly fetal alcohol spectrum disorder, is significant here. So we did have discussions about developing a court instead of focusing on an issue, trying to focus on a number of issues and taking each participant where they're at and identifying their own specific needs as a way of starting to support them to address these issues. Not surprisingly, we were not successful in getting funding through the drug treatment court call for proposals, but it did generate enough interest that we were able to secure some federal and some territorial funding to launch in 2007, which we did. So our objectives when we started were first and foremost to reduce the revolving door of recidivism. Like most courts in the country, we tend to see the same people over and over again. I can tell you, I, as counsel, doing child protection work, have dealt with kids that are now adults in our adult system and have seen them sort of throughout their lives coming into the system in different ways. So part of what we wanted to do was stop that revolving door. We wanted to reduce victimization and the harmful impacts of crime, ensuring that victims are supported, providing offenders with a therapeutic alternative that's specific to their needs, and providing therapeutic and restorative justice alternatives for sentencing. So that's what we started with as our objectives. Now, we did experience some significant growing pains because of our size. The first and foremost was simply resource limitations. There were at the time of development a finite number of programs available, and there was significant competition with other programs to have access to those resources. We experienced some significant philosophical differences between some service providers, specifically around substance abuse, and whether or not court-mandated treatment can be considered voluntary, notwithstanding the fact that this process is entirely voluntary. We did have certain service providers that were not prepared to take individuals that were court-mandated, and of course funding were significant limitations for us. In response to those difficulties, we were able, not me specifically, but others involved in the development were able to negotiate with certain agencies and service providers the priority given to CWC clients. They were able to develop a number of partnerships with other government departments, in particular what is now mental wellness and substance abuse services, partnered with community resources and nonprofits, and were able to develop connections with a number of the First Nations, partly with respect to programming, but also with respect to assistance in funding specific out-of-territory programs for individuals that required it. And the really big thing that we did that made a massive difference was when we were struggling to find adequate resources, we opened what we called the Justice Wellness Center in December of 2010. So it's sort of a one-stop shop for us. It's about a block away from the courthouse. We centralized all of the reporting and much of the programming there, and they are responsible for ongoing program development and adapting program to meet emerging needs. So for instance, one of the big things they've been looking at over the last couple of years is how we more effectively address opioid addiction. They look at various different models so that we've got a broad range of things available, including individual counseling, group counseling. They will adjust programming for any of the clients that have cognitive limitations, who may struggle in the regular programs. This goes up and down a bit. We currently have 2 clinical counselors on site, but at times, depending on whether the positions are filled or not, we've had to rely more heavily on external sources for clinical counseling, but we do have 2 at the moment in the JWC. There's a contract for psychological and functional assessments when we need them, contracts for culturally relevant supports, elders programs, peers programs, those types of things. And they offer an open area for clients just to drop in when they need to. It may be for a cup of coffee, it may be for a bite to eat, it may be for some additional support because they're in crisis. Whatever it is that they need, if they have nowhere else to go at that moment, they're able to drop in and spend some time at the JWC. So let's talk about the process. The core process itself, I suspect, is not altogether different from what most programs across the country are. Other than I will say, it's not a diversionary process for us. It's a process where there is a sentencing at the end, and the clients are expected to accept responsibility at the beginning. But the roadmap in terms of what our process looks like is we start with a request for suitability assessment. That is conducted by the Justice Wellness Center. If they're found suitable and want to opt into the program, it does require a guilty plea to something. They certainly are entitled to negotiate, as in any criminal case, with the Crown as to exactly what pleas are going to be entered. We generally do an agreed statement of facts at the beginning. That's to ensure, and it's a more recent development, I guess, over the last few years, because we did find difficulties on the treatment end when there wasn't clarity as to exactly what the client was accepting responsibility for. And so this led to us doing an agreed statement of facts at the outset. They do need to agree to be bound by specific release conditions that are related to their participation in the process, in particular, random testing and supervision and programming. They do sign a waiver with respect to the delay in sentencing and the agreement to participate in random testing. From there, we do the development of their wellness plan. Then they go through the wellness journey, completing the wellness plan, and then we get to sentencing at the end. So I'm going to give you a little bit more information about some of those things in terms of how we do it. Because our court is not, this particular court is not specific to a type of offense, we did have a lot of discussions about the nature of offenses that would be allowed into this process. So the starting point is the individual has to be facing charges for which an addiction issue, a mental health issue, FASD, or another cognitive impairment is a contributing factor to their offending behavior. Offenses that are straight up not eligible are any offenses resulting in a death, any offenses for which the Crown intends to make a dangerous offender or a long-term offender application, and offenses for which there is a criminal organization or gang element. We do have a kind of in-between category of offenses that are presumptively ineligible. So offenses against abuse of children or seniors, sexual offenses, serious personal injury offenses, and any profit-motivated drug trafficking. We do have individuals that are before the court with addiction-motivated drug trafficking, but as a general rule, we don't take profit-motivated drug trafficking. But this group, they can be admitted into the court with the consent of the Crown. So generally in those circumstances, they do the suitability assessment that informs everybody's understanding of the individual a little bit better and before assessing whether or not there should be an exception made for them to come into the court. I can say by and large, it tends to be a treatment driven decision as opposed to a legal one, except if we're talking about very high-end serious offenses. All right, so suitability assessment. This is done at the JWC, as I said. They're screened by the CWC treatment team for suitability. The focus is really on motivation to engage in programming. We don't mind at all if part of their motivation is that they don't want to go to jail, but there has to be some degree of motivation for them to actually engage in programming and start addressing those underlying issues. They will assess risk and safety concerns to determine whether or not it's an individual that can be appropriately managed within and safely managed within the resources that we do have. And if the individual is in custody, they will explore appropriate release terms and placement, as housing tends to be critical for success with a lot of the clients that we see. They use a number of different screening tools with a number of different acronyms, and I would certainly not be the one to explain all of those, but they have worked towards having consistency with other treatment providers in the territory in terms of the screening tools used so that we avoid any duplication, namely that clients don't need to be rescreened when they go to another service provider. Once they're into the program, then the wellness plan is developed. So for our process, it's not built around this specific programming, as in the clients would come in and do these 3 programs, and at the end they would be sentenced. What we decided to do was focus on each participant individually, to meet them where they're at in terms of assessing their needs, assessing their skills and their abilities. So the wellness plan that's developed is unique for each participant. There is no standard program or programming that is followed by everyone. The starting point is looking at all of the social determinants of health and identifying what programming is required, both in terms of treatment, life skills, other types of programming for a particular client, but also they spend time looking at what supports are needed to assist the person in being successful in the programming. So an obvious example would be if you've got somebody with a significant addiction issue and they're residing in a place where other people living there are actively abusing substances, it becomes incredibly difficult no matter what programming we offer for an individual in those circumstances to maintain sobriety. So obviously, one of the supports we would look at is the possibility of different placement or housing arrangements. As I said, we also look specifically at the client's circumstances, skills, abilities, those types of things. So for instance, a wellness plan for an individual with an FASD would be very different than one for whom we're dealing only with an alcohol addiction. Because of the lack of or the compromised executive brain functioning, the wellness plan becomes about wrapping supports and services around an offender with an FASD, as opposed to creating a plan of expectations that they're simply not going to be capable of meeting. We want to meet them where they're at and really focus on what they need around them to be successful. They do involve the client themselves in the wellness plan development. They will involve the client's First Nation, their family, other supports in the development to make sure that they are adequately addressing all of the issues that need to be addressed. So they do look, as I said, at the social determinants of health, and they look at a number of different issues in assessing that, all of which are listed here on the screen. So what the case managers at the JWC do in terms of looking at all of these things is identify where they require assistance and how best we're going to provide the assistance and supports. Some of it might be programming related. Some of it might be as simple as assisting an individual to get proper identification documents. Part of it might be assisting them in talking to the driver control board about getting driving licenses back, those kinds of things. Part of it might be how do we support them in addressing childcare or transportation concerns so they can attend at programming. So they look at all of those circumstances in developing the wellness plan to make sure that it meets all of the needs of each particular client. From there, the programming itself is done both in-house and through referrals to other agencies, some of which are listed here. So the programs will change depending on what we're seeing for needs. Right now, the programs that they're running based on the client group we have right now is there's a trauma-based program called Seeking Safety, the Respectful Relationships program, a substance abuse management program. They're also doing one-to-one counseling at the JWC as and when required, but the programs offered do shift depending on what the needs of the clients are. There are then programs offered through referral agencies, mental wellness and substance abuse being one of our main referral agencies. They do inpatient and day programming. They offer programming with respect to anxiety, depression. They offer CBT programming, substance abuse. They have a forensic psychiatric team. So there's multiple services that we access through MUSU, which is the way that we pronounce it. We also have access services through the Fetal Alcohol Spectrum Disorder Society, FASI, and Challenge. Those are two organizations that support clients with cognitive impairments. They offer general support, but including assistance with getting people to appointments, assisting them with banking, budgeting, those types of things. And Challenge also offers support in terms of employment and housing. We deal with both the Connective Society and Housing First for Housing. Creative Works is the counseling organization that has the contract for psychological assessments. And we also look at the Independent Learning Center in Yukon University for educational needs. And in addition, there's, as I said, work with First Nations as and when they have programs. There are also referrals to them. Quanlin Dunn, for instance, has a really good land-based treatment program at Jackson Lake that is used quite frequently. From there, once the wellness plan is developed, individuals are closely monitored and supervised by the case managers at the JWC. They do case conferences when individuals are struggling to determine how we might adapt the wellness plan. If it's not working, they do regular testing to ensure that they're staying clean. I will say the testing, if it comes up positive, part of the process is that will not lead to charges. It's simply something that they use to monitor how they're doing at any given time. We fully expect slips to be part of the process. So the approach is not a punitive one when we're talking about individuals who are struggling with maintaining sobriety. They do intensive case collaboration with other agencies, and they adapt the wellness plan as required. From there, the individuals come for court check-ins. Again, because of our size, we don't have the ability to sit a therapeutic court every day. There are 3 judges in the Territorial Court, so there are limitations as to how frequently we can sit. So we do what we call therapeutic court Mondays. So on one Monday, I will sit Community Wellness Court, and the next Monday I sit our Domestic Violence Treatment Option Court. So we go back and forth. Now I will adjourn individuals into the opposite court if we need to see them more frequently. So I might see a CWC client for a check-in on a DVTO day, just if they need to be before the court more often. The length of the program is 12 to 24 months on average. It depends on a number of factors, including the level of complexity of the individual's needs, the length of time it takes to get them stabilized in the community before entering into the programming set out in their wellness plan. It may be that we're working around seasonal employment, so it takes a little bit longer for them to get through their particular wellness plan, because we do want them to maintain their employment. But So a number of those things will drive how long it actually takes. So it's different for each individual. They make frequent court check-ins initially. They taper off over time. If they're doing well, they don't need to come and see me as often. We have a pre-court meeting at the start of every Monday when we review how everybody is doing, and then the actual appearances are in the afternoon, and all of the resource personnel attend the court to provide information about how they're doing and recommendations on any next steps or changes or things that we need to look at. We do have a basic approach of managing compliance and non-compliance with rewards and sanctions, as a lot of therapeutic courts do. The rewards change depending on what we have available at any given time. One of the main ones tends to be frequency of attending court, because people prefer not to come as often, particularly when it reflects that they're doing well. Once we get to the end of their wellness plan, there is a sentencing. So generally it happens upon successful completion of the wellness plan. Some people don't successfully complete, and at that point, the question for me is, what credit should they be given for partial completion, for what they did do in the process? So as a general rule, I should point out that this particular the client group that we ended up attracting, I think we thought initially would be lower level offenders, but we actually, the majority of our clients are individuals that have extensive criminal records and have been involved in the criminal justice system for an extended period of time. So one of the big benefits to their engaging in this process, aside from the benefits to them personally, is that successful completion generally means a community-based disposition as opposed to a significant period of time in incarceration. Once the sentence is then actually, if they successfully completed and are still actively engaging in their wellness journey, they will be supervised on their sentence through the JWC as well, so that we can continue. That they're all designated as probation officers, although they only work out of the JWC. They don't take other probation clients, but that allows for the case managers to continue to supervise the individuals once they make it to the sentence, and work with them on ongoing programming, but also transitioning them ultimately out of justice-based resources and into other available resources, because we can't keep them involved in the justice system forever. So that's sort of the end of the process for us. And in terms of numbers, when we started, we averaged about 8 to 10 participants at the beginning. But once we developed the JWC, that increased fairly significantly for us, to basically quadrupled. Primarily, I think, because there was a lot more that we were able to offer the participants. We, right pre-pandemic, had peaked at about 50 participants on average, but the pandemic actually had a significant negative impact on our numbers, primarily because most of the resources, the programming and the treatment available shut down because of the pandemic. So I suspect that's probably something that happened across the country, but our numbers did drop dramatically. They have been increasing again over the last year as things opened up again. So we're back up to 30, and we have 6 in the suitability phase at the moment that are being assessed. Okay, we have evaluated this process a number of times, and on the eve of the pandemic, we're actually in discussions with respect to having a further evaluation done. But the 3 that have been done all indicated that we were meeting our objectives. And the most important thing, I think, from my perspective, is the most recent evaluation indicated that of those participants that had successfully completed, the recidivism rate was 11.5%. Which is significant for the particular client base that we have. As for most of them, pre-wellness court, it wasn't a question of will they reoffend, it was a question of when. Because most of them, as I said, have had extensive involvement in the system. So the 11.5% is a dramatic drop for this particular group. And even the group, the people that didn't successfully complete, but that partially completed, their recidivism rate was around 30%. So even for a lot of them, there were some improvements, notwithstanding the fact they didn't significantly or didn't fully complete. All right, I just want to talk quickly about sort of lessons that we've learned over the last 15 years. And what I would say are at least my top 10 best practices in terms of doing this kind of work. So first and foremost is developing a multidisciplinary group that collaboratively both develops and manages the process. So the more resources that we were able to pull in, the more we are obviously able to offer. Now, they don't all have to be on steering committee because that gets a bit unwieldy. It can be done through partnerships and other types of relationships that are developed. But the more people that you involve, the more areas of the broader your range of expertise, the more informed the planning is, and ultimately the better the program is for the people that are participating. So next on my list is really making sure that anybody involved in this type of work becomes comfortable with the notion of giving up control. Which is, I have power and control issues, so that's not necessarily an easy thing to do. We're all used to working in our particular area, and it's easy to become entrenched in the way that we normally do things. So part of this is about learning to let that control go, to avoid turf wars, and to recognize that at the end of the day, this isn't about us, it's about the people that we're trying to support and help through this process. And some of these are interrelated. So the next on my list is really about the importance of effective communication. And when you bring a multidisciplinary group together, one of the things that really struck me is how very different the approaches were for the people coming from a legal background and the people coming from a treatment background. In some ways, we don't speak the same language, which created some communication difficulties. But more important, there are very different levels of comfort with conflict. So lawyers work in a very adversarial system and had no difficulty whatsoever with a very heated debate that made some of the people coming from other backgrounds very uncomfortable. So part of it was learning how we effectively communicate with each other and ensure that there's effective facilitation of the group so that all of the views are heard and respected. Again, interrelated with that is recognizing that ultimately these kinds of processes depend heavily on the individuals involved and the relationships that are developed. So it's really important to make sure that you're nurturing those relationships. And in an area like ours, people keep changing. I'm not sure you get the same degree of turnover in other places, but we have significant turnover. So there's always new people involved. And so there's an education process and an orientation process that has to happen for them to then become effectively part of the team. And it's important that we do a lot of cross education, because that's part of learning from each other and helping us understand each other. Next is being on top of what's happening behind the scenes. So there's not a lot of moving pieces. Everybody is also got other job responsibilities outside of the therapeutic courts. And it's important to recognize that you don't develop this kind of process and then it just functions independently, indefinitely. The group needs to be on top of what's happening. Otherwise, you might see with changes in personalities in various positions, there may be a drift away from what those original program goals were. And we did experience it here, where there were arbitrary decisions being made in one area that was fundamentally changing the process. And it took a while before we realized what was going on and registered that we had a problem. So I highly recommend making sure that you pay attention as to what's happening where, because the program itself can shift and change on you. Next, and this was pretty big for us, part of how you avoid that is, I call it non-partisan coordination. But what I mean by that is having somebody that's ultimately responsible for the coordination of the process, who is not beholden to any of the particular stakeholders, but rather is answerable to the steering committee, because their focus then remains on the process as opposed to the interest of their particular stakeholder organization. So that was a big issue for us, maintaining the independence of that position. We started out with a coordinator. It's now the manager of the Justice Wellness Center that, so the position morphed into the manager position from the coordinator position. I also, the other thing that we found that was hugely successful was having dedicated case management. So with the JWC as a separate entity, we moved away from having probation case managing it. At the same time, they were also managing a caseload of sentenced clients, which created some difficulties. But having a centralized place where the services and the supervision happen, and having individuals whose job is only to case manage the individuals in the process makes a significant difference to maintaining that focus on therapeutic outcomes. Connected to that is recognizing, and this was big for us, that one size does not fit all in terms of programming, and we're much more successful when we focus on the particular client's needs, when we get a little bit creative in how we meet those needs, and where we respond to their skills and abilities in terms of how we frame it to make it as easy as possible for them to go through what is a very difficult process for a lot of them in terms of the underlying issues and historical trauma that it requires them to begin dealing with. So we really focus on treating the whole person and meeting them where they're at. Next, you want to accept that the work is never done. So there's a part of me that keeps thinking you'll hit a point where everything is working perfectly and it's going to stay that way. And it's taken me a few years to accept that that is never going to happen. There are always shifts that happen either in programming availability or personalities, and we need to keep coming back to the table to adjust and adapt. We also learn from experience, and we need to be incorporating what we've learned into the process so that it continues to evolve and meet the needs of the people we're there to help. Next, which is a biggie, for me, was really redefining what success means, because there is no process you're going to develop that's going to magically fix everything. So when you're looking at the clients and meeting them where they're at, part of that involves adjusting our expectations and redefining what success means. So I tend to think of it on a continuum in terms of both the frequency of being charged, and also the degree of severity of the offenses that they're committing. And if we can take someone and move them down that continuum so that we're seeing them less frequently, and what the offenses that they're committing are less serious, then we're starting to make a difference. Now, that being said, we do have and have had a number of clients who have been successful and have really been able to sustain that over the long term as well. So there's some wonderful success stories, but there are also people that we see more than once, and we keep moving them down that continuum. So we don't have a policy saying that if you've been in once, you can't come in again. We have several people that have been with us more than once, and we keep coming back to see what we might be able to do and how we might be able to adjust in supporting them to continue moving down that continuum. And the last best practice from my perspective is really just patience, patience, patience. It's the kind of work where there's lots of ups and downs. There's times where things are going really well. There's times where things aren't going really well, both for individual clients, but also for the process as a whole. And I maintain patience by really focusing on what it is that we are trying to accomplish, because what we are doing has and will continue to have significant impact on the people that are in front of us. So I just wanted to end with some of the comments that people have made, and some of our participants have made in the evaluations that have been done, because that reminds me just why this work is so important and why it's so valuable. So my final slide is just my email address. And like most of the people doing this kind of work, I am more than happy, and our group is more than happy to share any of our any of the things that we've learned with other people who are looking to do this same work. I find that that's how we all learn and improve what we're doing. So you should feel free to send me an email if you have any further questions. So that's essentially my presentation at this point. I'm going to stop the share and see if there's any questions that people want me to answer right now.
Thank you so much for all of that this afternoon. That was absolutely fabulous. I loved your top 10 takeaways. That's a genius list. Very, very helpful, I'm sure, for many people online today. And as you mentioned, we're happy to take any questions, so feel free to use your Q&A feature. We have a few minutes left. And while we're waiting for some questions to come in, I just thought I'd ask a little bit more about your pre-court meeting that you have. I wondered a few questions regarding this meeting. I wondered, do you attend the meeting? And
that's a very interesting question, because it's a dilemma for us. We have a three-person court. And so if I come into information before somebody's in the process, and then they decide not to enter the process and they enter a not guilty plea, it has the potential for conflicting me out as a possible trial judge. So we were really mindful of that, because it would make me really unpopular really quickly. So what we decided to do for Wellness Court is I sit in at the beginning of the pre-court meeting only to discuss the individuals that are in the process.
okay.
So once they've done all of the admission requirements, the pleas are entered, the waiver signed, the conditions are there, and they're actively starting within their Wellness Court journey, then I do participate in those, and then I leave. So when they're talking about possible candidates, I'm not there for any of that discussion. And for our domestic violence court, I'm not there at all. There was a concern when we developed the domestic violence court about some of the information that might be covered and whether it would be appropriate for the court to hear some of it. And there was real discomfort with having the judge there for that. We've talked from time to time about whether to revisit that, but at this point, the judge doesn't attend the DVTO pre-court, but attends for the updates on the individuals in community wellness court.
That makes sense. And it sounds then like a fair bit more information is discussed in those meetings than what is actually put on the record at the time of appearance. Yeah,
they actually provide us with written updates on everybody. So we'll get that in advance. And then there is a discussion about, so all of the defense counsel there, Crown are there, and all of the treatment people, and there's a discussion about what's working, what's not. There's a section for discrete information, things that they think everybody should be aware of, but they don't want them raised on, don't want it raised on the record. There might be a discussion about how to best do the check-in in terms of particular issues that should be addressed by the judge and how they can most effectively be addressed, those kinds of things. So yeah, we're discussing progress and what should happen at the check-in, basically.
Great. We have a few questions here from the audience now. One person would like to know why gang-related crimes are automatically excluded from the program.
Interesting, because at least historically here, we haven't had a lot of gang-related crimes. We are a territory, not a province. Bear with me, this will make sense. We are a territory, not a province. So the powers that the territory has are different. And some of the things are still dealt with federally. So most notably, prosecutions of criminal matters are done by the federal government, the PPSC, not territorial prosecutors. There's certain national priorities in terms of what they will agree can be dealt with in an alternative way. And one of those is criminal organization. So it was something that the Crown itself required in terms of participating. And I suspect that came from Ottawa.
And another similar question from Debbie, who thanks you for an excellent presentation. She wonders what criteria are used to determine whether an intimate partner case will be accepted or not.
Oh, okay. And okay, so that's our second court with the Domestic Violence Treatment Option Court. But we do, if an individual has complex needs with a domestic violence offense that are beyond what we would deal with in the DVTO court, they can come into wellness. So they do screens, including the SARA, in assessing whether or not somebody's going to be able to participate. Again, motivation. We do have, as part of our multidisciplinary group, there are victim services is involved. So there would be some consultation through them in terms of the victim's position. When we started DVTO, we found we were a little bit different than some other areas where in large urban centers where there were domestic violence offenses, often individuals would split. We saw the majority of them actually wanting to stay together. So when we developed it, part of it was, can we come up with a therapeutic approach that's going to keep everybody safer? And so the screens that they use do include a focus on safety and risk in assessing whether somebody comes in. And they do everything that they can to have ongoing input from the victim, both with respect to admission, but also with respect to how what they're saying and doing in programming, to make sure that, so there's some validity checking there to make sure that the information that they're getting is valid.
Okay, thank you. And we'll do one more question here as we're running out of time. Anonymous attendee would like to know what kind of harm reduction programs are available in Whitehorse, and are there safe injection sites?
We do actually have a safe injection site. Yeah, I mean, it's a bit of a thorny issue, right? So there is a a local shelter that offers a lot of services that shifted from a harm reduction perspective, from a requiring sobriety to allowing individuals not to use the services without being, because it really wasn't realistic. There's a community outreach services. So there's an outreach van that it does a lot of on the ground work in terms of assisting. We've got a number of agencies involved in trying to support and assist our homeless population and others that are struggling with addictions. There is they just opened in the last couple of years a housing unit, again, that is designed specifically for individuals that are struggling and not able to maintain sobriety. So those would be the main things we have at the moment. But again, things shift here a lot. So you never know what's going to be here tomorrow.
Yeah, that's true everywhere. Well, again, thank you very much for taking the time to be here with us today. That was an absolutely fabulous presentation. And the association, thanks everybody for joining today. Keep an eye on our website, justicetreatment.org. We always have events every month, so keep an eye, and we'll see you all soon. Take care.